Hello, and welcome to On Air with Akin Gump. I'm your host, Jose Garriga. This is the closing episode in our three-part miniseries on ESG, or Environmental, Social, and Governance, matters featuring Akin Gump financial regulatory partner Ezra Zahabi. And it's been quite a ride. If you've been listening along, as I hope you have, you'll have learned what you need to know about the EU's Sustainable Finance Disclosure Regulation, or SFDR, and the Taxonomy Regulation. In this episode, then, we look at how the two interact, as well as at other topics you should bear in mind if you're doing business in the EU. Welcome to the podcast. Ezra, thank you for returning to the show today to wrap up this great mini-series. So as I mentioned, let's tie together then the themes of the first two episodes. How would you describe the interaction between SFDR and the Taxonomy Regulation?
So the SFDR really sets the framework for a broader disclosure regime relating to ESG matters, and in particular risk mitigation and approach to risk by investment managers and other financial institutions across a whole range of products. And it touches on sustainable investment, but really its focus is something else altogether. The Taxonomy Regulation, however, does two things. It introduces for a subset of products to which the SFDR disclosure obligation applies, it introduces further additional disclosure obligation. And in addition, it also introduces a kind of framework for defining sustainable investment with respect to green investment, really. And in particular, in the short term, at least, with respect to climate-related change and mitigations. So they are sort of complementary pieces, but they do different things. And so the Taxonomy Regulation kind of requires additional disclosure to some products to which, but not all products to which the SFDR applies. And it sets forth to kind of try and set out a kind of shared dictionary or a shared taxonomy, as it were, of what in fact would be considered green at this stage. And over time, the intention with the Taxonomy Regulation and further iterations of it, there's going to be further detail on what other types of green products might be, or green investments might be, not only climate related, and in the further future still, a taxonomy for what is meant by socially sustainable products and activities.
Thank you. As I mentioned in my introduction, let's move beyond then these two and look forward a bit. Do you see any movement upcoming on the legislative or regulatory fronts to supplement or refine or expand SFDR and the Taxonomy Regulation?
Very good question. There, in fact, is a whole host of legislation that exists currently and that form part of the broader efforts of the European Commission in creating a comprehensive ESG framework. Examples of existing legislation include the low carbon benchmarks regulation and the revised shareholder rights directive that requires quite comprehensive disclosure on shareholder engagement and approach to governance. But there are a number of legislative initiatives and developments in the works. And some of these are more broadly applicable to financial services firms, but many of these are, for investment managers, are of greater concern from the point of view of their portfolio companies, and potentially in some circumstances in terms of attributing responsibility and therefore potentially incurring liability, either at the level of the fund that holds those portfolio companies or, arguably in some circumstances, potentially at the level of the manager. And so examples of more recent legislation and or legislation in the process of being developed are the EU Conflict Minerals Regulation, which imposes a requirement on EU companies to ensure that they import specified key minerals from conflict-free areas and from providers that have sourced them without the use of forced labor. And this, the types of minerals included really, they can be found in many, many types of products. So this regulation has potentially quite significant impact across multiple sectors. There is a kind of a draft legislation. So the Parliament approved a proposal that they submitted to the Commission. So it's in the kind of EU's legislative process on EU corporate social responsibility. The proposed rules would mandate the performance of due diligence on kind of the environmental practices and standards of the companies themselves, their own operations, those of their subsidiaries, as well as across their supply chain and their subcontractors. So pretty broad scope. And also on kind of human rights factors, potentially social factors, labor rights, that kind of thing. So very broad scope. And so the rules would require this due diligence. They would also require the publication of information regarding these due diligence processes and the findings. And, in practice, sort of a kind of a mapping of what the potential risks identified would be, and the establishment of a kind of risk mitigation monitoring framework. Another thing that this proposal does is that it introduces a new civil liability regime, which would make the undertakings liable to remedy or compensate for any harm that would arise out of adverse impacts on human rights, the environment, good governance that their failures in their due diligence process have either caused or contributed to. And so that contributed to, I think, is a problematic provision. I mean, clearly these rules are in their infancy yet. But for those, to whom these sound like very ambitious rules that would likely be watered down, it's worth noting that they are heavily based on existing law in France that has imposed similar type of liability and similar type of responsibilities on companies headquartered in France. And so there's good existing precedent on which these proposals are being fashioned. And a kind of significant point to note on this is that it would also introduce a basis for civil claims by persons or communities who had been adversely affected by these, failures in the due diligence process that have caused or contributed to, adverse impacts. And so there are some examples already of civil actions that have been brought in different EU countries and in the UK against companies for their poor environmental practices, or in some cases for the kind of harm suffered in the community. For example, the assassination of community leaders protesting against sort of projects that are really projects of large international companies, to which there's local opposition. So it kind of introduces a whole different kind of framework across the EU for companies who are failing in terms of the comprehensiveness and appropriateness of their due diligence. Also notable for companies outside the EU is that, at least in its current form, it has proposed extraterritorial application. So it is proposed to apply to non-EU entities which sell goods or provide services in the EU. So it would potentially have very broad reach indeed. In the UK also, there are similar developments. There are plans to amend the existing Modern Slavery Act, and that currently requires certain organisations to prepare and issue public reports on identifying risks of slavery and human trafficking within their operations and their supply chain. And so the revisions are proposed to enhance the due diligence processes required and the public disclosure made attendant to that. They are not too dissimilar from, in sort of principle rather than detail, to the EU Corporate Social Responsibility Bill. There's proposed amendments to the UK Environment Bill, which would introduce mandatory human rights and environmental due diligence obligations and prohibition on the use of certain illegally produced forestry products. And another sort of legal development that's just worth mentioning is the European climate law. And so it's a proposal for regulation, so directly applicable across the EU, that would establish the framework for achieving climate neutrality. And so it seeks to transform the kind of political promises and the political agenda into a binding legal obligation at the EU member state level. And it would create a legal framework for the kind of irreversible and gradual reduction of greenhouse gas emissions and enhancement of removal of greenhouse gas from the atmosphere by natural other things in the EU. It's clearly linked to the Paris Agreement goals and the commitments by the EU to achieve net zero greenhouse gas emissions by 2050. Really what it does, it kind of contemplates the powers for various EU institutions and member states to propagate legislation as they see fit to enable measures to be taken and initiatives to be launched in order to actually achieve this net zero status by 2050. And so it's very much a framework law, but in it contemplates, I think, the possibility of multiple legal initiatives, both at the member state level. So, for example, tax initiatives or tax relief measures that are currently the responsibility of the member states rather than an EU-wide. So tax is not only the subject of EU legislation that's handled at the member state level, but also like other sort of measures or, legal basis for establishing other projects, perhaps that might be either member state specific or EU-wide. So I think that's a kind of a roundup of recent legal developments that I think are pertinent to the generation of a kind of an ESG legal framework in the EU and the UK.
Thank you. That's interesting. So picking up a thread, something you've said regarding risks and liabilities, what do you foresee as emergent risks and liabilities, in addition to the ones you mentioned, coming out of this regulatory framework, both the actual and projected?
It's a great question. I mean, some of it is, fairly easily contemplated. But to quote the great Rumsfeld, there's lots of unknown unknowns here. And so clearly the things that we can contemplate, I think, are civil litigation and or regulatory action on kind of greenwashing or other kind of misrepresentations or inaccuracies in sort of public reporting, whether by issuers or by investment managers in respect of their funds. So some of it is, like there might be a risk around historic disclosures. That is, if ESG suddenly is so important, how come you didn't contemplate making these disclosures historically? There's a risk around whether the existing disclosures, especially given the state of sort of unsettled state of consensus around, what the disclosures actually should look like. I mean, it's new law. There's a lot that's still unclear and formally subject to clarification. And people are making disclosures at a time when they don't actually have the sort of final settled guidance available. There's risk around inaccuracies, perhaps around that. And just more generally, there's risk, I think, in terms of trying to balance the kind of opposing drives of, on the one hand, the attractive investment proposition that is an environmentally friendly or sustainable investment product. And then on the other hand, not really overselling, what the fund or the manager actually does. And, having in place sort of internally sufficiently robust methodologies and systems and processes around considering ESG in the investment process to sort of uphold any challenge to claims of greenwashing. And then I think that those are kind of probably issues at the manager level in respect of the actual products being sold. I think that there are sort of multiple issues at the investment level, really, and the value of the investment. The regulatory discourse around climate risks is very much based on the fact that they say that it really affects, you have to start thinking about risk more broadly because climate risk affects bottom line. And so it affects performance of your actual investments. And the climate related risks can be, they can be sort of broadly dipped into two buckets. So one is physical risks. So, what happens if you've got investments in geographical areas, for example, that are subject to, significant weather changes or flooding and so forth. And then there are transition risks. And those are, like risks that may be driven by changes in consumer behavior or perception, which make some products less attractive suddenly than others, or changes in regulation or, the lack of availability of subsidies, for example, or government funding, or in fact, privately available funding for like certain types of projects or certain types of companies in certain sectors. So those are kind of performance related risks. And then finally, as I was discussing earlier on, the legal risks around the actual portfolio companies and their operations. I think that that's significant. It seems that, there have been a few recent cases, I think that Akin's been following and covering. In the Netherlands, for example, there was a case of Shell, where, Shell and the Dutch government, Shell, was basically ordered to reduce its carbon footprint by 40% by 2030, and the similar kind of requirements for the Dutch government to reduce its greenhouse gas emissions. And I think there's some precedent in attributing liability to the parent company for the actions of its subsidiaries, and this kind of expansion of the potential liability, not only to subsidiaries, but also to the supply chain more broadly. I think those present really significant commercial risks and that managers will need to think quite carefully on. And I think that another sort of interesting development, there was some recent UK case law that's that suggests that parent companies that implement group-wide policies could incur liabilities for the breach of those policies by their subsidiaries. And so the regulatory action for the breach of these types of requirements at the subsidiary level is, an interesting proposition. Probably more so because often, hand in hand with regulatory or public investigations or administrative actions, for example, go then stakeholder litigation. And so, stakeholder actions, to try and sort of change policy, as well as shareholder or other stakeholder litigation against the company in connection with ESG failures, sort of resulting liabilities from those. I think that's something also for managers to think about and consider what kind of precautions they might take.
Thank you. So to wrap up this series, and you've presented so much good material for people to think about and look into, what are a couple of thoughts that you would offer listeners just to distill some of the insights and notions you've presented? What would you say people's takeaways should be from everything that you've covered so far regarding both SFDR and the Taxonomy Regulation and the new material that you've discussed today?
I think that it is a case of, approaching this not from we'll try and keep business, state of business as usual as much as possible, and just try and do what we have to in order to comply with the letter of the law at the moment. I think that the whole framework and the direction of travel really indicates a kind of larger paradigm shift, not only in investment. I think, yes, in kind of investment and for investment managers, but just more broadly, I think in terms of, operationally, where sort of structurally Western kind of post-industrial societies, and other and emerging markets where we are headed structurally. I think it's important to get your head around what the actual legal requirements are and what you need to do at the moment to comply, as well as, have some kind of vision as to what is the business of the firm going forward and what is the relationship with ESG. Is it something that it will actually start to have an impact really on the kind of the investment thesis that the managers have internally and their, broader approach to investing? Because I think that for those, who are open-minded and who are sort of fluent in what the requirements are now and going forward and, understand the risks, I think there's a lot of opportunity around ESG. I sort of see all of these changes really, as a kind of part of something that is a kind of a change in the common sense. And I think over time, people will, ESG will no longer be something that is still seen as a kind of a tag on to your existing true processes. It will inform all of the processes going forward. I think that the way to look at it is not to look at ESG as a kind of a compliance exercise. It's really, a way to look at it as an opportunity to reassess, philosophically, where the firm is in terms of its investment philosophy. Where the firm is, where the manager is. If really looking at risks from an ESG point of view, what are the steps to be taken around risk mitigation and around management and understanding what data is available and what you need.
Thank you. Listeners, you've been listening to Akin Gump Financial Regulatory Ezra Zahabi. Thank you so much, Ezra, for making the time to sit for this great mini-series. I know listeners have been learning so much about these critical regulations and the trends shaping them. And I will preview that folks should keep an eye out for our upcoming episode on ESG litigation risks. So thank you, listeners, as always, for your time and attention. Please make sure to subscribe to On Air with Akin Gump at your favorite podcast provider to ensure you do not miss an episode. We're on, among others, iTunes, YouTube, and Spotify. To learn more about Akin Gump and the firm's work in and thinking on ESG and financial regulatory matters, look for ESG and regulatory at the Experience and Insights and News tabs at akingump.com. Take a moment to read Ezra's bio on the site, and then visit our Speaking Sustainability blog, which features our lawyers' thinking and analysis on all matters ESG related, as well as our Speaking Sustainability Twitter. Until next time. On Air with Akin Gump is presented by Akin Gump and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.